Yes, sir.
My lord. My lord, this matter, my lord, pertains to the allegations against the petitioner. With reference to that, my lord, Manipur violence, my lord, lordship is well aware of. In 2003, there was a violence, my lord, between two groups, the Meiteis and the Kukis, my lord. My lord, this FIR, my lord, is related to one of the incident therein, my lord. My lord, in this case, there are total 10 accused persons, my lord, in the entire case, my lord. And total 6 were arrested, 4 were granted anticipatory bail, my lord. And my lord, 8 accused, my lord. All out of 10, my lord, as on date, 8 accused are out on bail. And 2 accused, including the present petitioners, are in judicial custody. Out of that 2, my lord, myself and the other accused, my lord, he has not yet preferred any bail application before any court.
Just a minute. এই আগৰ কেছটোত এইকেইটা ভৰাই থকচোন আগৰ কেছটোত Yes.
Now, my lord, 2 are there, my lord, in judicial custody. Out of that 2, I am 1, my lord, and another 1, my lord, he have not preferred any bail application with regard to this case, my lord. My lord, and that accused person, my lord, he was referred by the NIA, my lord, to the CBI. And in the NIA case, my lord, Supreme Court has granted him bail on 11th of December, my lord. That is the, my lord, larger conspiracy, my lord, case he already got bail. So maybe he will be filing here, my lord. So, my lord, the position is out of 10 accused, 8 are on bail, 2 are in judicial custody. My lord, in this case, my lord, the CBI after investigation have filed total 3 charge sheets, my lord. In the and the 3 charge sheets included 10 accused persons. My lord, the present petitioner is named in the second charge sheet, my lord. Now, let me take your lordship to the FIR, my lord. FIR is page 20, my lord, annexure 1. This is the form, my lord, page 20, 21. Lordship, may kindly come to page 21, the bottom portion, my lord. Lordship have got it. The government of Manipur, lordship. The government of Manipur by notification number so-and-so dated so-and-so and is corrigendum dated so-and-so issued under section 6 of Delhi Special Police Establishment Act 1946 has extended the power and jurisdiction of the members of the Delhi Special Police Establishment in the whole of the state of Manipur for carrying out investigation of FIR number so-and-so dated so-and-so under section so-and-so. The government of India by notification number so-and-so dated so-and-so issued by Department of Personnel Training, New Delhi under section 5 of the Delhi Special Police Establishment Act 1946 has also extended the powers and jurisdiction of members of the Delhi Special Police Establishment in the whole of the state of Manipur for carrying out investigation of the above referred case and any attempt, abatement and or conspiracy. In relation to or in connection with such offences and or for any other
Is this notification in any manner relevant to the prayer for bail? No, please take us to the portion where what that is relevant for the purposes of bail, sir.
Then, my lord, kindly come to the content, my lord. How the FIR, my lord? They have
they came in different vehicles. They looted the police station and
station, my lord.
Armed court. What they call in I think a magazine. Yes,
that is the FIR. Now, my lord, with regard to the present petitioners, my lord.
His role. What is his role?
The charges, my lord.
The role played by him during that incident. Where is it?
My lord. Page 118, my lord.
Yes. What is your name?
I am Asim Kanan Singh, my lord.
Okay.
118, my lord. IPC sections 143, 148, 391, 382, 440, 447. Arms Act, my lord, 25(1)(ab), 25(1)(b). Then, my lord, PDPP Act, section 3. UAPA, my lord, 16, 18 and 20. These are the allegations, my lord. 143, my lord, it is 6 months or fine, my lord. 148, it is 3 years or fine. 391, my lord, it is up. My lord, 391 is a definition section they have put in. It should be 395. It is up to 10 years and fine, my lord. 382, it punishment is up to 10 years and fine. 440 is up to 5 years and fine. 447 is 3 months and fine up to 500. 25, 1AB Arms Act, my lord, minimum 10 years and may extend to life. 25, 1B Arms Act, my lord, is minimum 2 years and maximum 5 years and fine. Section 3 of PDPP, up to 5 years and fine. 16 of UAPA, my lord, minimum 5 years and may extend to life and also fine. 18 UAPA, my lord, minimum 5 years, may extend to life. 20 UAPA, up to life and also fine. Now, my lord, the facts of the case is that out of all the looted weapons, not a single weapon was recovered from this present petitioner. That is a fact, my lord. If anything is recovered, they will submit, but that is the fact. Nothing has been recovered. Now, my lord, kindly come to para 16 point. May I take your lordship through the entire charge sheet or only the relevant portion which is relevant to me, my lord? Then, my lord, kindly come to 16.8, page 122. During the course of further investigation of the instant case, I am reading, my lord, 16.8. During the course of further investigation of the instant case, information was received through reliable sources that Meitei outfit Arambai Tengol was allegedly involved in various activities related to violence in Manipur in 2023, including looting of arms and ammunition from the premises of the second IRB, Naran Sena and Asim Kanan Singh, that is the petitioner, and erstwhile police constable of Manipur Police is the operator main leader of the said outfit. The source further informed that Arambai Tengol was formed in 2020 by 1K Kuman and came into prominence after the ethnic conflict between the Meitei and Kuki Zo communities broke out in May 2023.
When were you arrested?
Arrested, my lord, 8/6/2025.
8/6/25.
My lord.
Okay.
Now, my lord, this is the allegation that the present petitioner is member of an organization named Arambai Tengol, which was involved in some criminal activities, and they say that this present petitioner is the main leader of the said outfit. Now, my lord, I'll show to the court that they have come to what conclusions and on what basis, my lord. Now, my lord, for a moment, kindly come to 16.9 at page 123. On 8/6/2025, Asim Kanan Singh at channel
On page 124, 7, 8, 9, 10.
123, I'm reading, my lord.
I'm at 124.
My lord, 120.
7, 8, 9, 10.
124, 7, 8, 9, 10. Yes, my lord. But again, my lord.
Then 125, 6.10.
Well, my
Then
lord.
16.13. 16.13 is
Yes, well, I'll reply, my lord.
what is devastating for
I
you.
will reply, my lord. I request, my lord, kindly, my lord. I request in this case, my lord, some patient hearing, my lord, because, my lord, this is, my lord, a critical case, my lord. And, my lord, I'll fail on my duty, my lord, if I don't place the facts properly.
We will fail if we don't hear you. So we'll hear you. We just point out those paragraphs, not because we have framed a mind, but because those are the paragraphs perhaps you will be required to address.
My lord,
Which have caught our attention and you have to address it.
my
Do not for even a second think that we have made up our mind.
my lord. So, my lord, I am reading para 16.9, page 123. On 8/6/2025, Asim Kanan Singh at Kanan Singh was put under arrest in the present FIR. During custodial examination, he revealed the following facts. Presently, he is a commander of mobile team of Arambai Tengol. He joined the outfit in 2023 after eruption of ethnic clashes between Métis and Kuki militants.
Hmm.
He is in charge of mobile team which is responsible to reach out the spots of Métis which were attacked by Kuki militants and retaliate. After outbreak of ethnic violence, Kuki militants attacked Métis with sophisticated weapons. Under this scenario, the volunteers of Arambai Tengol assembled and demanded for such weapons to give effective retaliation to Kukis. On denial, they attacked and looted arms from different arms knots of Manipur police. On 3/8/2023, when clashes between Meti and Kuki were going on at Chura Chandpur, all Arambai Tengol members were directed to loot arms and ammunition from 2nd IRB Narasenha Bishnupur for giving retaliation to the Kukis. Accordingly, the unit commander along with more than 500 volunteers of Arambai Tengol attacked 2nd IRB and looted arms. Asim Kanan Singh at Kanan Singh confessed to have taken possession of an SLR from the looted weapon which have been looted from the north of 2nd IRB Narasena Bishnupur. Asim Kanan Singh at Kanan Singh also disclosed that the looted arms and ammunition could be recovered from the volunteers of village, namely Pangi Wangu. So he also disclosed that he was in possession of 4 pistols at Imphal and that he was using the same for the purpose of extortion. He hid these pistols in the premises of District Agriculture Office, Imphal, Manipur. A disclosure memo was prepared on 10/6/2025 in this regard. In pursuance of this said disclosure memo, recovery of 4 pistols, magazines and some documents have been made, which is part of the charge sheet. He made a draft sketch of the house of those residents of Payang village in Imphal West district who are in possession of some of the arms and ammunition that were looted from 2nd IRB on 3/8/2023. A disclosure memo has been prepared in this regard in the presence of the independent witnesses. Prevailing law and order situation, however, did not allow the investigating officer to go ahead in the matter. My lord, so these were the information which allegedly were revealed by the accused, my lord. Now, my lord, on this point, my lord, I would like to submit on section 23 of BSA, my lord. Why, my lord? Because it clearly says, that is old section, my lord, 25 and 26, that confession to police officer not to be proved. And my lord, it is not admissible at all, my lord. Section 23, my lord, BSA says no confession made to police officer shall be proved as against a person accused of any offense. No confession made by any person while he is in custody of a police officer unless it is made in immediate presence of a magistrate shall be proved against him. Now, my lord, why I am making this submission? I am making this submission so that, my lord, now these facts has come from my mouth as per the investigation. What they are alleging that this has come from my mouth. So, my lord, it is hid by the section 23 BSA, old section 25-26 of the Evidence Act. So, my lord, apart from this, now let us see what they could discover. And my lord, on the discovery of the 4 pistols, and my lord, about the SLR and all, I'll make submissions, my lord, in my later part. Now, 16.10, my lord. At the time of arrest, Kanan Singh was found using 2 mobile handsets, Vivo and Ulu make. The said mobile handsets were seized and the same were sent to CFSL, New Delhi, for mobile forensic analysis. The analysis could extract a video wherein K. Khuman, chief of Arambai Tengol, is lucidly visible giving hate speech against the Kuki community, and accused Asim Kanan Singh is standing just behind him on the bonnet of a car wearing a mask, holding weapon in his hand. This piece of evidence clearly established that Kanan Singh was closely associated with Khuman, the founder of Arambai Tengol, the Meti outfit responsible for looting arms and ammunition of 2nd IRB, Narasena Bishnupur. Now, my lord, in this case,
Mr. Counsel, we are considering a petition for bail. We are not trying to consider a petition whether you are required to be convicted on the evidence collected till now.
my lord, this is since UAPA is involved, my lord. Lordship has to enter into certain facts and see whether there was any material at the time of his arrest and whether there is any material in the case record which,
In a bail application,
my lord,
we'll enter into that arena.
no, my lord,
Will we enter into that arena in a bail application, sir?
So, my lord, because lordship has to be prima facie satisfied that he is not involved. Prima facie satisfaction we have to give, my lord. This is UAPA. For that, lordship has to enter, my lord. For that, my lord, we have to keep detailed argument.
Let's carry on.
My lord. Now, my lord, here at para 16.10, my lord, they are submitting about some video, my lord, which they have allegedly recovered from the mobile phone of the accused. Now, my lord, and there they are saying that K. Khuman, the chief of Arambai Tangle, is giving some speech, and I am standing behind him wearing a mask on the bonnet of a car. My lord, they have conducted for TIP, my lord. The investigating agency have conducted TIP. But, my lord, no TIP was conducted with regard to this video, my lord. Nobody, no witnesses are there who have identified me in the said video. That should have been done. That is completely absent, my lord. There is no witnesses who have come and who have seen the video, and after seeing the video, they have identified that yes, this is the accused Asim Kanan Singh whom I identified. Nothing is there, my lord, of that sort. And my lord, they have brought up the name of K. Khuman, and they have said that the present petitioner was closely associated with him, so and so, my lord. But this K. Khuman, my lord, he is not an accused in the case. Nothing has been investigated with regard to K. Khuman. Neither arrested, nor charged as absconder, nor any investigation done with regard to K. Khuman. So there is a missing link, my lord. Then 16.11, my lord. During the course of investigation and further investigation conducted so far, in the instant case, statements of witnesses have been recorded narrating the sequence of events that happened on the day of incident. A photo TIP proceeding was conducted on 27/8/2025 by the officials who were on duty at 2nd IRB on the day of incident, that is 3/8/2023, in the presence of two independent witnesses. During the photo TIP proceedings, witnesses have identified Asim Kanan Singh as the person who was part of the large mob involved in looting of the arms and ammunition from
Mr. Counsel, we'll take this up at 2
my lord. My lord.
because others are waiting. We simply can't keep on reading the statements like this. Kindly formulate, kindly take out, these are the lines. I have gone through, I will be frank with you, I have gone through almost the entire petition. I had just started reading the objections. If you can just point out this
I'll
page,
try.
these things are there, and therefore I'm making this submission. You can summarize whatever you want to
My lord.
impress. We need not go through it line by line. You can tell us that this is what has been stated. This is my argument, that just like you said that that man has not been proceeded against with, whereas I was found standing behind him. One sentence, sir, will do.
I'll do that, my lord. I'll do that.
But we will not take this issue to be a long hearing at this last week of the people are waiting.
Application prima facie offences has required to be seen.
We are just to
Which
see,
pattern
we are
of
just to
action-
see whether this man can be set at liberty or not, and if there is any illegality in the
These are the matters-
arrest process. That would perhaps
I'll
suffice.
47, 48, also 36, 1B.
Come down to that. If you think that that is sufficient enough, and in many of our orders we have done that. We have recorded 30-page arguments by the counsels and concluded in 2 paragraphs saying that 47, 48 others need not be addressed. So that is simply a waste of a lot of resources. If you have got a solid point to say that this is the point where I need the bail, just give me that. Elaborate long arguments.
My lord, I'll just make
Doesn't
the
work
point
today, it will
submission
work on
their
some other day.
allegation, my lord.
Huh?
What allegations they have brought?
You have said 47, 48, we'd be so happy to look into it. You said 35 also, we'd be happy to look into it. If you say that this is why I cannot be convicted, there is no no possibility of a conviction on
My lord, that is fine.
that is another, but we need not go through sentence by sentence.
I will not go, my lord.
Huh?
I understand, my lord.
We'll all try to make it a
I-
bit concise.
My lord, I'll give a concise argument.
Yes, next.
Obliged, my lord.
Yes, sir.
My lord, I will,
Would like to apprise one thing before my learned friend will start. There was a notification, this matter is related to UPA Act and the schedule offenses are there. So this bail application is not maintainable here, it will go division bench. One.
that's all from single bench only, my lord.
Other
The
others?
bail orders well from the single bench.
Yes, that was maybe wrongly or rightly. At that point of time, I could not able to get this notification. And that is why, and just now I got.
What was the notification? And all those orders would become without jurisdiction.
We are, my lord, normally taken up by the single judge only.
No.
Rightly or wrongly, at that point,
Whether after the bail applications or the appeal matters, my lord, that has to be seen.
Hmm?
Whether the appeal has to go before division bench or even the bail has to go before the division
but
bench.
in UPA.
Whether
one
389
appeal will
has to
lie.
go. In some
Appeal
cases,
will lie. Section 21.
section 21 UAPA.
Which are you showing? Which part?
Last
Last two.
page of this notification. Because UAP Act is imposed 15, 16, 20. And section 21 speaks about the appeals.
Madam, UAPA Act, you are referring? Rules or?
21, section 21. Section 21.
This is NIA Act, madam. This NIA, National
National
Investigating Agency Act 2008.
8.
This is not UAPA, madam. That will go to division bench maybe, but not UAPA. Section 21 of the UAPA deals with punishment for holding proceeds of terrorism. That section is different. That is from NIA Act.
There are certain which are the schedule of it under this act.
Madam is referring to this notification pursuant to the order of the Honorable Supreme Court, designate following cases to deal with the matters as indicated above. Special Judge CBI and NIA, Courts of Chief Judicial Magistrate, presiding officers are so and so. Then where is she saying that this notification requires it to go before the division bench is what I'm not being able to trace out. এখন dioption,
Last page, your lordship. Last but one notification is there.
just show us that it has to go before the division bench.
So special judge CBI NIA Assam.
It is
Pursuant
special
to
judge.
Order of the Honorable
No,
Supreme.
you are saying the division bench.
So, no, section says, it is a schedule offense. So for schedule offense, it is a schedule offense.
আপনি মোক নোটারিজ এখন কেলে দিছে ভাই নোটারিজ এখন দিছে আপুনি মই বিচাৰিছো নাপাওঁ
The NI Act of the schedule offense is given in the NI Act.
Download করছো NIA এখন।
Falls under the unlawful.
So you say that it should go before the division bench. Hmm. Hmm. Has to go before.
I would have an appeal under 20. Their practitioners lordship.
Hmm.
Passes a order lordship. Now give them. The session code act.
Hmm. Hmm.
Very clear in 4, notwithstanding anything contained in subsection 378 of the code, an appeal shall lie to the High Court against the order of the special court granting or refusing bail.
Section number
NIA.
Or the session code.
It has to be empowered because of the notification. It is,
Yes.
and it is empowered to act.
It has been empowered.
So I just find it.
Because
It is empowered, Your Lordship. And the CBI special case court number 1 is also empowered with the NIA. And this matter is pending there, NIA. CBI/NIA, it goes like that in the.
yes, sir, what do you say?
I'm looking into it, my lord.
I would be exceeding my jurisdiction.
Don't think so,
Huh?
my lord. Power to transfer case to where.
Because this section is of,
We can have this
Activity
discussion a
previous-
little later. You
previous
also
time.
go through it. We are just passing it over for the time being. Let him get the orders. You
Yes,
also
yes.
go through it. We'll address that issue first.
My lord.
If we can take up the matter, definitely we'll take up the matter. There is no hesitation.
Once I'm ready, my lord, I'll inform the court.
Please.
Grateful, my lord.
Take it up from Peter.
My lord, now, my lord, they have brought up two things, my lord. I believe tips argument. My lord. First, my lord, they have put one notification of the Honorable Guwahati High Court. That notification is in pursuance to this order. This will answer that notification.
Tell us, I have that. You just read it out. I have that judgment with you. You can just read out the relevant portion.
So, my lord, kindly see. Para 1, that the details of the cases which has been transferred to the CBI at present point are in tabulated below. So table is given 27 cases. Para 2, at the present case, bearing in mind the overall environment in Manipur and the need for ensuring a fair process of criminal justice administration, we issue the following directions. We request the Chief Justice of the High Court of Guwahati to nominate one or more officers of the rank of Chief Judicial Magistrate and Session Judge in Guwahati, Assam. Why? It will be answered here. The Chief Justice of the Guwahati High Court is requested to preferably select the judges who are conversant in one or more languages of the state of Manipur to facilitate the proceedings. All applications for the production of the accused who are in remand and judicial custody, extension of custody, and all other proceedings in connection with the investigations are allowed to be conducted on the online mode, bearing in mind both distance and security issues at the court, which will be so designated under 1 above. So, my lord, this online mode has been mentioned in the notification of the High Court. Kindly take up the notification for a moment, my lord. Notification dated 31/8/2023 of our High Court. Pursuant to the orders of the Honorable Supreme Court dated 25/8/23, passed in SLP diary number so and so, Honorable Chief Justice has been pleased to designate the following courts to deal with the matters as indicated in the aforesaid order in respect of the cases which has been transferred to CBI for investigation in the online mode. 1, the Special Judge CBI and NIA Assam, and the Court of the Chief Judicial Magistrate Kamrup Metro Guwahati, as well as Additional Chief Judicial Magistrate Kamrup Metro Guwahati. The presiding officers of the above courts are permitted to take the services of interpreters, preferably from the staff of the Guwahati High Court or district courts who are conversant with the language spoken in the state of Manipur. Now, my lord, other things are also there. 4, 5, 6. For what purpose, my lord? I'll read, my lord. 4. The judicial custody of the accused, if and when granted, shall be permitted in Manipur in order to obviate transit. The statements of witnesses under section 164 CRPC are permitted to be recorded in the presence of a local magistrate in Manipur or
We have
in the-
gone through that. So you are
my
trying to
lord,
say that only
and CJM and additional CJM will not be permitted to conduct, my lord, UAPA case, my lord. What type of arguments they are doing, my lord? Additional CJM and Chief Judicial Magistrate, my lord, they will conduct UAPA cases. And my lord, the High Court, my lord, High Court have passed that two judgments, my lord. That this is the answer, my lord. This is a notification, my lord, 31 May 2023.
investigation in the online mode, madam. Only to facilitate the investigation part.
Transferred here also, subsequent also Supreme Court order is there that all the matters are transferred to the Guwahati.
As per this notification, my lord, 8.1 of the judgment in criminal in bail application 341025, my lord, para 8.1. In the instant case under section 22 of the NIA Act, special courts have been set up within the state of Assam. White notification number E297135/2 dated 31/5/2023. Further, it appears that the present accused has preferred one bail application before the special court so constituted under section 22 of the NIA Act. And White order dated so and so. This is the thing, one. This notification has been mentioned by the honorable by our two different benches of this honorable High Court, and it is held that appeal will lie. As simple as that, my lord. This, my lord, it is mentioned in 8.1 of that judgment, my lord, in the bail application, which they have placed, my lord. Now, my lord, if I have to elaborate further, my lord, I can elaborate from the NIA Act, my lord. Act itself says the state government will notify the court, and that court, my lord, has to be court of one or more court of sessions, my lord. Now, my lord, the state government cannot direct a CBI court to do something. That is under the Central Act. And the NI Act itself provides that the state government can direct the court, can consider the court of sessions as a special court. It is there in the Act. I can show, my lord. May I, my lord?
Yes, this notification is only for the purpose of investigation in the online mode.
Not it there.
It does not have any other powers of the NIA court.
Notification are there that is
What?
given in their application itself in paragraph number 2 in compliance of the notification dated 12/8/23 under section 6 of the DSP Act of the Government of Manipur and corresponding notification of so and so of under section 5 of the DSP Act issued by the Government of India. The said cases were transferred to CBI from for further investigation.
Mm.
So thereafter another
So
notification is there.
because many
Where
of the
state-
people,
State has
many
transferred.
people were within the state of Assam due to their fiasco. Many people were here. They could not have gone back for the investigation part. Supreme Court made a request to the Guwahati High Court to
This is
constitute these courts only for the purposes of investigation online mode.
another notification is also there of section DSP
come up in
5 and
peace-
6. 5 and 6.
If you come up in peaceful manner,
5 and 6. It is because they have already taken note of the fact. It is in their application, and we have also given in our objection also, your lordship, in the first paragraph itself.
Eh,
There is a notification of section 5 and 6.
where is
6
your
is
way?
notified by the Manipur government and 5 is of the CBI.
কেটা
So
matter আছে
government
আমার
has
বাকি?
given a
Just a
consent.
minute. কেটা matter বাকি আছে? মোটামুটি।
State government has given a consent. It is under section 5 and 6 of the DSP Act.
My lord, if NIA Act
You are with behind bars from when?
8/6/2025.
8/6/25 and where do you state in that that it should go before a division bench? Where do you state that in this?
Objection, my lord, there is
Objection?
objection.
Have you taken that up in the objection that this is not the appropriate forum?
In my objection, this notification is already there.
Where?
Page number 280.
Huh?
280.
Wait,
Schedule 4.
what does it say?
All notifications are there. The state government has transferred it to the CBI.
Mm.
And thereafter Supreme Court has transferred it to the Guwahati High Court.
Mm.
It is already there. All cases are transferred.
So,
280.
so where does it say that They have been constituted as courts under the NIA that shows that.
Yes.
Because prevention, this section itself is a schedule offense.
Under the NIA. Under the NIA.
It has to be tried by the NIA court.
Mm.
And if there is any order passed by the NIA court,
So which is the NIA court here which has passed the order?
CBI NIA.
Then why did you move it there if it is not the competent court?
My lord, may kindly take up the NIA Act, my lord. Kindly for a moment, my lord. This is not.
You are not answering. You are not answering my.
My lord, I am sorry, my lord. My lord, can I get a question again, my lord?
You are trying to say that this court is not a NIA court. The court which rejected it.
Yes, this is not under NIA Act.
NIA Act. Now under the NIA Act, it is a scheduled offense. UAPA is a
Their
scheduled offense.
Offense admitted, my lord.
Then appeals from there have to go to the division bench.
My lord, but
Or am I understanding it wrong?
there are two things, my lord. First, the investigation has to be by the NIA.
Hmm.
Then it will go to the NIA court. Second, if it is state constituted NIA court, then it will fall under section 22. Nothing more than that, my lord. CBI also is empowered to investigate UAPA cases. CBI is empowered. CBI has investigated. Under the NIA Act, my lord, I can show from the Act, there are two things, specific things at the cost of repetition I am submitting, my lord. First, investigation has to be by the NIA, then it will be NIA court. And second, if the state government designates a court of session as NIA court and case is pending before that court and that court rejects the bail, court of session designated as NIA court by the state government, that court rejects the bail, then it will be division bench, my lord. Appeal before the division bench.
But the CBI court is NIA court. That empower designated court.
The district magistrate is also the district revenue officer, is also the so-and-so, is also the so-and-so, is also the so-and-so. I think he has got 11 or 12 officers running under him.
But the NIA Act cases are conducted there.
My lord.
NIA cases are conducted there.
My lord, this CBI court is also NIA court. I agree. I agree, my lord. But if case is investigated by the CBI, it is acting as a CBI judge. If cases are investigated by the NIA, the judge is acting as a NIA judge. Just like we say district and session judge.
Let us take up this matter. If we are found to be without jurisdiction, take it up there. Get it set aside that we could not have done it. Because in the other cases where the orders have been passed, nothing has been done. Has this ground been taken up? These are sudden flashes of intelligence which comes to
It has
certain
No,
people
we have
who
already assembled
convey
the
it
Supreme
and then a confusion is created in the court.
We have assailed it before the Supreme Court.
On this ground, that it should have been before the division bench.
That I am not aware because CBI has taken up the matter.
That is what I'm saying. Some people get flashes of intelligence to prolong the proceedings, to confuse up everything, and then to have it held up. Either you show that this is an order passed by an NIA court, or the investigation is
Yes.
done under the NIA Act.
The designated court is CBI and NIA court. That court passed the order, it is a NIA court.
Are we being unintelligible? Are we being unintelligible? Can we not be understood? The question that we are asking? Our question is very simple. Where is that bail rejection order? Kindly show us the bail rejection order.
This is at 157.
Page 157. This will come very heavily now, man. Page 157, it may come, yes. Page 152 is a part of it. Page 157 is a part of it.
And
Is it?
Last page
The
is
last page of the order.
in
Kindly
view-
show it to us.
67. In view of the above discussion and reason, the
Who has signed it? Who has signed it?
PI.
Special Judge CBI. Is it an NIA court? Or NIA court? Or so-and-so court? Or is it there? Is it acting as the NIA court? You still want to continue to argue that it's a NIA matter? Seriously, we are asking you, madam.
But the section
We have
imposed,
spent
the-
half an hour in the first.
the section imposed is of the unlawful activities prevention.
True.
Act.
The
And-
only the NIA is empowered to investigate into offenses of the unlawful whatever. Only NIA is empowered. No
Yes.
other agency can investigate into allegations. No, we are not with you now. So every case under the UAPA is with the NIA, is your submission. Should we record all this? And then should we
There's-
adjudicate on your submissions?
Sessions courts have having power. State session court is also having power.
So just inclusion of the UAPA will not take it into the NIA. Are we in agreement with that? The order which has been passed by the special judge CBI was not under powers under the NIA. Are we in agreement with that? Was it exercising powers as the court under the national, under the NIA Act? Yes, we are losing breath. We are talking too much. Yes.
This case is lying there, CBI having the.
So
also
today we will
power.
not decide the bail. Today we will decide whether this court can take up the matter or not. In case we find out that this is a frivolous argument being made, not only the detention of the petitioner, but the court's time which has been, not only the court, the person sitting here waiting for some matters to be called, all this will be taken into account. Are you seriously contesting that this court cannot take up the matter? We are not trying to impose it.
Submission before your lordship, now it's a lordship discretion. Is also lordship discretion to pass an appropriate order.
Yes, you argue. Your contention for the time being is rejected. We will not say. You have to give us a summarized argument,
My lord.
take us through every of the.
My lord, firstly, my lord, let me point out the violation of section 36B(1) of the BNSS.
I did it deliver. Give me a- এটা থাকো, এটা থাকো। এটা আমি কইলাম, এটা আপনি আমার কথা বললে বেশি কইলাম। Yes?
My lord, section 36,
Ah,
small b, Roman 1 is violated, my lord. Section 36 says procedure of arrest and duties of officers making arrest. Every police officer while making an arrest shall, I am reading small b, prepare a memorandum of arrest which shall be, Roman 1, attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Two things, my lord. One, the arrest memorandum of arrest will be signed by the member of the family. Or if nobody, member of families are not available, one of the respectable members of the locality where the arrest is made.
where is the arrest memo?
My lord. Listen. Arrest memo দেখুন, page number, আন্টি দেখো, তারপর মাথা না। My lord, page 99. We have also provided typed copy, but I am taking to the original copies. Page 99. This is the memorandum of arrest, my lord. My lord, kindly see column number 7. That is important. Date, time, and place of arrest. 0806-2025, 9:20 AM, Imphal Airport, my lord. Now, kindly, my lord, come to column number 17. Column number 17. Name and address of the independent witness, whether friend, relative, or member of family, so and so, as per section 36B(1), member of family of the person, so and so. So, my lord, whatever they have written, my lord, as per section, but whatever. My lord, who signed it, my lord? Rajesh Meena, SI, CBI, ACB, Guwahati. And my lord, he is the person who was authorized to arrest me. Kindly come to. I'll have to give a document, my lord. Document 45 to Jason. Document 45.
Madam, any explanation as to how Rajesh Meena is a relative, member, a friend, or member of the family, or that he is independent of the case?
This is more disturbing, my lord. This document, my lord. This is the authorization, my lord. Whereby, my lord, last paragraph, my lord, I'm reading. I hereby authorize Sri Rajesh Meena Sub-Inspector and Sri Manish Kumar Sub-Inspector, both posted at CBI ACP Guwahati, to locate the present whereabout of said Kanan Singh and arrest him. They had the authorization from superior officer to arrest me. And he is signing, my lord, my 36(1)(b), my lord. It's clear violation, my lord.
To whom were the grounds of arrest given?
My lord, grounds of arrest, my lord, I am arguing, my lord. Page 103, my lord, of my bail application.
03 in persons where? No, to whom was it given?
Grounds of arrest, my lord, it was given to me. 47, it was given to me.
48?
48 not given, my lord. And my lord, 47 also, my lord. What I mean to say, what I want to argue, my
Found
lord.
his club secretary friend
Yes.
on his phone number as the mobile phone of his wife was switched off at that time, was at his house. So information was given to so-and-so elder sister that the accused has been arrested.
You have type copy also, lordship. If
Thank you.
this, my lord, whatever grounds of arrest they have given,
In
this cannot be
looting of
called a,
arms and ammunitions from so-and-so. Yes.
my lord, these grounds of arrest, my lord, at page 103 cannot be called a grounds of arrest, my lord. I'll place the remand order. Remand order এটা copy মই পাম নেকি? তাই copy আছে নেকি? Remand order to দিয়াচোন sir.
Where is
Kindly see the remand order, my lord. Second page and grounds of arrest, my lord, in the remand order. Second page, lordship will find. Second page, second last para, my lord. The IO in his forwarding report has mentioned the following grounds of arrest of the above named accused person. So distinctly, my lord, they have placed in the forwarding report before the magistrate. These 5 grounds, my lord. And when they are communicating to me, my lord, they are saying that too, that I am involved in the looting. And my lord, entire this.
We would not like to go through this remand order because this is not where we find the grounds of arrest which was communicated to you. What you were communicated was at page 104.
Yes.
Is it not?
Yes.
Now 103.
103, 103.
Now in 103, what more details were required to formulate it into a ground of arrest?
My lord, in 103, my lord,
The date, the time, the incident, the place of occurrence, the allegation against you, all is there.
allegation is mere reproduction of the FIR, my lord. Then again, my lord, on that point also argue, my lord. Allegations, my lord, in the grounds of arrest.
Now, 30, what did you say that, here is the page?
36(1)(b, my lord.
Where did you, what was that page number?
86, my lord.
Page number 86, yes, page number 86 is something which is
83, no? 83, my lord. No,
from
86,
83 onwards at page 85.
Yes, yes, type copy is there. Hold a second. Page 99.
Yes, madam, this page 85.
I'm from the city, this original replica
Tell
is
us
there.
who
The
was
original
informed?
list is there.
Who was informed?
He has received A.K. Kannan Singh. A. Kannan Singh, he has received himself.
Hmm. What about the rest of it? 3B1. He has received it and he has taken it inside the cell with him. Then there is a necessity that someone else has to be informed. Page 85. Number 17. Column 17.
Column 17,
Name and address of the
Rajesh Meena.
no, name and address of the
Independent.
independent witness. Now this comes on record to show that he is the person authorized to arrest.
I am coming to that one.
How is he independent?
I'm sorry. He cannot be the independent
Then
witness.
effect of violation of 36B1. What is it? Is it the same as 47, 48?
Yes, my lord, I'll satisfy my lord. Kindly, these two judgments I am placing.
Uh-huh.
DK Basu, my lord knows only. Effect, my lord. On Calcutta High Court judgment, my lord, bail was granted, my lord. 36B1 to 41B. No? Yes, my lord, this is Kolkata High Court one judgment is there. Old section 41B, my lord. Why not?
Hmm. Yes.
That is DK Basu, my lord. 35, 2 and 3 guidelines, my lord. Guideline number 35, 2 and 3 violated, my lord.
Hmm. And can you tell us this information, name, address, and email ID and telephone number of the persons informed about the arrest? When were they informed? That phone calls which were made to the club secretary, friend, and sister.
Assist.
When were they made?
Time and it is not given in the paragraph number 17. But they have called over the phone. It has been elaborated in the our objection itself.
At what time? It has been elaborated.
Coming to that effect, parawise reply is also there.
So where is that? Where have we alleged violation of 36? What paragraph? Counsel for petitioner.
Page number 255.
What page, what para number have you alleged violation of 36? 255. Yes, madam. 255.
55 of our objection
Ah,
of B.
ah.
Submitted that the accused applicant himself
Yes, we
provided
have read
mobile
it.
number.
We have read it. There is no time and date.
His wife, Pemoli Devi. to
It is, there
arrest
is no time and date. We were asking for the time and date. You had said it was elaborated. It is a cut paste of that particular paragraph itself. Can you give us the time and date? And from which phone number the phone was made? Their phone numbers have been given. The person whom you tried to contact. From which phone number was it made?
IO, he will definitely.
The IO is an independent witness. There is no IO. That is the problem. The arresting person, the persons authorized to arrest, become the independent witnesses. Hmm?
Explained in paragraph number 20 or
Paragraph number 20. Yes, we are trying to read paragraph number 20 also.
254 to 250.
254 onwards. Okay.
Paragraph number 30. And it is submitted that on 7/6/25, the reliable information was received. from-
Accordingly, a CBI team reached Imphal in the morning of, we do not know what morning of, what time, 8/6. Lisa Sem, for the submitted law and order situation could be taken to his house, WhatsApp. Hence, the information was communicated through mobile phone and WhatsApp only. Hmm.
The information of the arrest was also conveyed to the friend of accused.
No,
applicant,
it's an
as
airport.
motive as the mobile number provided. by
It is an airport.
in the airport.
So we will not take the ground that no responsible officer serving in the airports would have refused to sign. Can it be so?
In A, paragraph
Hmm?
A, the applicant himself provided the mobile number of his
Yes.
doctor,
Yes.
namely.
So that WhatsApp image in other cases also we had asked about that WhatsApp being sent to the particular number, from which particular number it has gone and to which particular number was it delivered to. It's one screenshot. Mandate of the law. You are required to serve it in writing. We have gone to the extent of diluting it to the extent that even a WhatsApp message service will do. Show us that a WhatsApp message was served. Statement is not going to work. Do you have the CD with you? No. You can trace it out from there. From which WhatsApp number it was sent to which WhatsApp number. Delivered, not delivered. At that time, at that point of time, if we remember correctly, internet was shut down in Manipur. From where did that WhatsApp number go? That WhatsApp go? To which number could it have been delivered when there was no internet services? We are just trying to recollect if we can help the CBI show that we did all that was in our power to do.
At one point of time, there was internet disconnection is there, but that is at the time of 2023 around.
Whether it was 23, there was internet disconnection.
Internet connection.
So he was arrested in 25.
Was
So
arrested
it was
23.
restored. Okay,
He
we'll
was
go by
trying
that
to-
also.
He was trying to flee because he is a constable. He was a state constable, state employee. He was dismissed. And thereafter he joined this organization.
Then what do you say about the other part of it, that arrest memo signing?
Signing, he has signed himself. And whatever the number is given by him, the IO tried to contact him, that mobile number, this mobile number, wife's mobile number and daughter's mobile number, Lija.
So if we interpret it strictly,
Wife, so,
a man is arrested on a lonely road, no traffic stopping there.
in paragraph.
Airport, yes, my lord.
The arrest memo goes. No, once we deal that, once we hold that,
That
it has to be signed in all circumstances. Then
Ali-
we have to take into account circumstances which may not be prevalent here, but it will lay down the law, saying that this is how it has to be done. In the absence of this has to go. Then there will be circumstances when arrests are made and people are not there to sign it. People refuse to sign it for whatever reason it be. In support of the arrested person, they refuse to sign it. The arrest goes.
On factual part, my lord, I may
Ah.
make a submission. They arrest me at Imphal, wherever at Imphal, my hometown, where I have hundreds of relatives. They arrest me at Imphal. They bring me to Guwahati, and now they say we don't have anyone to serve the Section 48 notice.
is.
What prevented them from serving the notice at Imphal, my lord? They arrested me. Arrest memo says arrested 9:20 a.m. Imphal airport. So very well they could have served a notice to my relative and bring me from there. They brought me here, my lord, without any notice, and from here they are saying we are connecting through phone. That submission, my lord, totally vague submission, total non-compliance, my lord, purposefully they have not complied, my lord.
Clause number 18 may kindly be read. Informed his club secretary friend Tingthang Nabam on his phone number so and so as the mobile phone of his wife Srimati Bimoli was switched off at the time of Tingthang Nabam was at his house. So information was also given to his elder sister. Clause number 18.
That is what we are asking you. Was that attempt to inform made from after coming back to Guwahati, the question that he has given us? Was it?
There only. They have
Hmm?
tried there only. Because this
We'll
is
have
the
this
mandate.
matter, we'll have this matter tomorrow again.
Right.
Kindly find out if no one, if the arresting authority himself signs as the independent witness, what is the consequence? That is the best we can give you today.
It
See
will-
all those reading of all those statements that you were reading out, was it necessary? It's a prolongation of everything.
humble submission.
That gave them the chance to come up with the Nia
My
thing.
lord.
Then
To tomorrow if it can be fixed.
day after tomorrow, no issues.
My lord,
Day after tomorrow, we just need to know he has now taken up the ground of 36B1 if it is signed by the arresting authority. And by respectable member, I don't think we need to have someone very at the top. Respect is respect for everybody. Anybody can be a respectable man unless you show he is full of disrespect.
A time and date is already given in the
Entire
clause.
Manipur airport did not have one person to come and sign it.
Because of the law and order situation.
In 2025, we are not talking of 2023 now.
Going on,
Yes.
that's why it is transferred here.
We understand that it is.
They cannot able to conduct the cases. in
We
the court. This is
we
the
understand that
situation.
part of it, but when the arrest is made, yes, I have seen him arrested. Is it not? The arrest has been made without law and order situation. Yes, the arrest is in my presence. That would not be a law and order situation. Anyway, but convince us on the effect of 36B1 when the one of the persons authorized to arrest has signed it without saying where he has signed it. He does not say at the Manipur airport, Imphal airport, and he doesn't say at the Guwahati office of the CBI.
If
Is it?
it is written on it.
With his signature, it was that attesting does not contain that term that it was done at Manipur in a hurry. No other person was involved. Is it not? These are things which will come up when this right to fundamental right, these things comes and strict. Otherwise, the process, yes, what you are saying is true. Practically, it may be true to some extent. In some cases, it may be true. We had put a question to him. There will be a situation where no one will sign. God forbid, there is an issue here. Someone tells us, yes, advocates sign. Every advocate will step back. I am not doing it. Is it not? It will be a dicey situation. Was it the situation? So therefore, we don't want to lay down that part of the law saying that unless it is by someone else, it has to go at any case. Therefore, the 2 days time, find out what you can. We'll have it day after tomorrow. Convince us that that is not enough for us to set aside the arrest.
Day after tomorrow at 2, my lord.
Day after tomorrow, there may not be at 2. There might be a continuous bench. We don't know.
No.
It'll come in the list. We'll see.
My lord, we have some brief argument we'll do, my lord.
Uh-huh.
Some more points we have, we'll argue on that day. if required.
But it has to be very short now.
Very soon, Lordship, second time I'm appearing before Lordship. So, my lord, now
We need very concise.
Yes, I have understood. Lordship.
Everywhere.
Yes, my lord. Henceforth, all arguments will be in that manner only, my lord.
Things which are not necessary
Yes,
to be
yes.
noted in the order, we don't, because once you say it, we need to note it down. Once we start noting it down, it is 40-page order.
Yes, my lord. I'll keep that in mind. Obliged, my lord.
Day after tomorrow.